33% by the current president of the family division and his predecessor, that these cases should not get to the family court at all. That is a huge waste of resources, a huge pressure on the children of the couples who find themselves in the family court. And if we can convince the public that the family court is the wrong place for many of these disputes, then that's a tremendous achievement. I'm Philip Marcus. I got my law degree at University College London. I was a solicitor in Stoke Newington for 2 or 3 years. And then we moved to Israel, where I qualified as a lawyer in Jerusalem. And in 1995, when they set up a combined specialist family court, I was appointed a judge. I sat in the family court for 17 years. That was quite enough. I took early retirement, and since then I've been researching and writing and lecturing, particularly on the areas to do with children who find themselves in the family court, and also about family court reform. I've been able to observe family court systems in many parts of the world, and together with Two Wishes, an organization which both David Curl and Nick Child were involved in founding, we've set up a law and justice advisory board, which consists of judges from 6 different jurisdictions: India, Portugal, South Africa, Scotland, Belgium, Portugal, and Israel. And we're drawing up a plan for what a model family court ought to look like. I'm hoping we'll produce something like that fairly soon. I'm also working with a group who are trying to work up a document which will be offered in the first stage on Facebook and by other people here in Israel, a sort of a roadmap or toolbox for separating parents, with a strong focus on helping children to get through the parental separation with as little damage as possible. So that's, I think, why Mike asked me to come on this call. Obviously, my experience hands-on in the courts in England ceased many years ago, but I have been observing, I have to say with horror, some of the things that are going on in the family courts in England and Wales, and in other jurisdictions. And there are, unfortunately, strong negative incentives for people to go to the family court. If there's time, I'll mention 1 or 2 of those as we go on. What I can say is that I endorse fully what Helen is saying about diverting people away from the family court before they get there. And I strongly agree with Elizabeth on the same lines. And one of the approaches that we are putting forward is for diversion at 3 stages. First of all, diversion away from the family court. As has already been said, we need to convince people, the public, that the family court is the wrong place to sort out relationship issues, that there are out there counselors and advice centers and qualified people who will help people through their relationship problems. And 30% has been mentioned, 33% by the current president of the family division and his predecessor, that these cases should not get to the family court at all. That is a huge waste of resources, a huge pressure on the children of the couples who find themselves in the family court. And if we can convince the public that the family court is the wrong place for many of these disputes, then that's a tremendous achievement. How to do that, I may, if I have time, I'll speak about that in a minute or 2. The second stage of diversion is what's going on in many jurisdictions, including MIAMS in England and Wales. And that is that at the very first stage, when people approach the family court, they should be diverted and told, look, let's see what's really going on here and try and sort things out without litigation. Of course, the legal profession consists, like all ecosystems, of sharks and beneficial fishes, and they may have some objection to diverting people away from the adversarial system, which most lawyers were brought up in. That's something that needs help, both from in law schools and in law colleges. And it's part of a change of public atmosphere as to what's going on when parents or when couples split up. But there has to be a very strong diversion element, subject to triage. I have an article which is actually about to be published in the coming days about triage in the family court. What that involves is when any application is made to the family court, it's immediately referred for triage, so as to sort out the cases which require an urgent judicial response, such as allegations of abuse, violence, and interference with contact between a child and a parent. But other cases need to be referred to dispute resolution outside the adversarial system. The third area of diversion is when the case actually comes before the judge. The judge should first interrogate the parties as to whether they have yet accessed extrajudicial, non-adversarial processes for resolving their disputes. And if they have not, then should refer them to that as a condition of making progress. Now, all of this requires an educational element that's already been referred to. How do we do it? Well, as has already been said, the newspapers all over the world are full of the most ghastly reports about what happens when people get before the family court. David has mentioned the murders and the suicides, and other people have mentioned what happens to the kids. One of the or some of the most eloquent people to speak about that are adults who, as children, were adversely affected by the fact that their parents were engaged in an adversarial process. And there's a great deal of benefit to be gained from harnessing these people, if they are prepared, and it must be very difficult for them, but if they're prepared to talk about what they went through because the adversarial process affected them. So we've spoken about diversion, and we've spoken about raising public awareness. The situation in England and Wales of the family courts themselves is far from satisfactory, despite the efforts made by Sir Andrew Macfarlane to try and sort things out. One of the terrible effects of LAPSO was that they withdrew legal aid from family cases, but put it back, legal aid for the person who alleges violence and abuse, but not giving legal aid to the respondent. That, to my opinion, educated as I was on the basis of level playing fields and cricket and fair play, is a most outrageous offence against any prospect of a fair decision. And having made an allegation of abuse or neglect, then the person making that allegation, knowing the other party is unrepresented, or is going to spend a huge amount of money on non-legal aid representation, can simply drag out the process. There's another counter incentive which follows from that, and that is, as has already been mentioned, the idea that safeguarding requires that a child not see a parent against whom an allegation of violence has been made until there's a fact-finding hearing 6, 9, 12 months or more down the line. That is monstrous. The presumption ought to be that a child needs both parents, and that if contact can take place with restrictions in a contact centre, and this is Elizabeth's area, or by electronic means, then contact should be retained in such a way as to protect the child, but not allow the allegations of physical harm to cause psychological harm by dissection of the family and breaking the ties with the parents, with one of the parents. As far as qualification of judges is concerned, our view is that there should be compulsory training for a judge who is going to hear family cases. These cases are completely different from the general run of civil or criminal cases that judges are educated to deal with. That requires training for judges and anybody who's actually going to hear from the level of the lay magistrates up to the higher courts. One more thing that I have to say, and that is that Sir Andrew gave a decision which was published a few days ago in RIC about experts in the family court. I think his decision is entirely correct and justified, but there has to be a cadre of experts, not only to give opinions before the court, but also to deal with reconciliation where there has been a breakdown of contact between a child and a parent. However, I go back to the point that Two Wishes has been emphasizing. There is a need for a culture change, and there is a need for alerting people to the dangers of both the dangers of adversarial proceedings and to the economic effects of badly run family separations. I've put up in the chat that I'm involved in a group here in Israel who've produced a research proposal which is aimed to show how efforts to prevent harm will cost far less than cleaning up after the harm has already been done. And I'll be happy to share that with anyone who's interested. And if anyone can find funding or partners for such research, I'll be delighted to hear of it. Thank you again, Mike, for letting me speak about this tremendously important issue. And I wish you the best of luck in rounding up people who are sufficiently able to influence the way things are going. As I say, there's a huge amount of publicity about what goes wrong, and you need civilized, decent journalists who are prepared to take this on, not from a gendered perspective and not from a sensational perspective, but sufficiently sensational to attract public attention so that legislators can do what legislators are supposed to do in this field. Thanks.